the whole issue probably could have been avoided with attorney advice from the get-go.
It could save you some cost and worry down the line.
The only way they could compel you to stop using the trademark would be to actually sue you in court.
If I withdraw my trademark application, can I continue to use my trademark?
If there's no trademark application, then there can be no opposition.
So actually the risk is quite significant that you're going to run into something. Hello and welcome. I'm Robert Games, Managing Director of Albright IP. Welcome to our podcast, Figure One, an IP Conversation. Today I'm joined by Joel Weston, a trademark attorney on our trademark team, who specialises in resolving brand name disputes. Joel, thank you for joining me.
Thanks, Rob. Great to be here.
Today we have something a little different for you, in that we'll be discussing the practical steps involved in settling a trademark dispute based on an inquiry to the firm. This is a real-life scenario. So to set the scene, we have a new inquiry from the recipient of a letter before action threatening opposition and requesting withdrawal of one of their trademark applications. The letter has been sent by an unrepresented party. The other side sending the letter has an earlier registered trademark, but we quickly ascertain that they are unaware that the recipient, our potential client, has been using their trademark for at least 3 years prior to the filing date of the other side's earlier registered trademark. To complicate matters, the would-be client filed their trademark application themselves without representation, but filed for a list of goods that was broad and somewhat imprecise. I'll be playing the would-be client. The scene is set. Joel, let's begin. So, I've recently filed a trademark application. It was accepted and published. And then, just after publication, I received a letter from an individual asking me to withdraw my trademark application because they own an earlier registered trademark. Can they do this? What are their grounds for asking me to withdraw my trademark application?
Well, thanks, Rob. This is a commonly received question that we have from prospective clients that receive letters before action, as we call them. Usually the person threatening the opposition will clearly state out the early registered rights that they seek to rely on. The short answer to your question is yes, they can attack your application on their earlier registered rights. There are several grounds that opponents can rely on to prevent the registration of trademarks. They range from owning earlier similar registered trademarks, like I think we have in this case, to the more unusual and exotic opposition grounds that require a lot of evidence to substantiate. Generally, you don't see them too often, or if you do see them, they're not often successfully pleaded. In this case, I think the threatened opponent would be seeking to rely on Section 5 of the Trademarks Act, in that they own an earlier similar or identical registered trademark that covers similar or identical goods and services to those that you're seeking to register yourself.
Sure. And given that I've been using my trademark for 3 years, which is, let's face it, quite a long time, can they still ask me to withdraw my trademark application?
Yes, they can still ask you. The prior use of the trademark would likely affect your answer to their request. If we have 3 years good, solid use of the trademark that predates their filing date, we may be able to counterclaim against the validity of their trademark and assert those prior unregistered rights that you own in the trademark through your use of that mark in the UK. When trying to establish a prior unregistered right through use, we would need to carefully assess the geographical scope of that use throughout the UK, or is it localized, for example, in one particular town? What goods and services have you used the mark for? Are they similar to the goods and services covered by the threatened opponent's trademark registration? And is the sign that you're using in trade sufficiently similar to their registered right? In most cases, you would expect a threatened opponent to be aware of these prior rights, but I think we'll look at that a little bit later in the scenario. But in this example, they're obviously not aware that you've been using the trademark. We could either take an aggressive response and just apply to cancel their registration, or generally speaking, I would advise that we take a more pragmatic approach and write back to them and make them aware that you've been using the mark prior to their filing date, and hence that renders their registration vulnerable to cancellation. On being made aware of that, you would hope that they would see sense and go away.
Sure. I am a little bit perplexed in that the UKIPO sent me a search report containing the other side's earlier mark. Does the UKIPO not consider the use of marks when issuing their search reports? Do they not search the internet for clear use? Do they not do anything like that?
They don't. They're very black and white, I suppose, with what they look for. They will look at the trademark that has been filed. They will then do a relatively brief search of the UK Trademark Register for rights that appear on the register. So they're only going to look at rights that they can see on the UK register, whether that's a pending application or a registration. So they're not going to look, for example, on a search engine and start looking as to whether you've used a mark prior to them or who has an earlier right within the marketplace. That they don't consider the context of the trademark or how it's used in the market. They will just look at what's been filed for and what's already existing on the register.
Sure. And if I withdraw my trademark application, can I continue to use my trademark?
You can. So quite often what I see with new clients is that they're not aware of the fine line or sort of the difference, I suppose, between obtaining a trademark and using the trademark in trade. So you could withdraw your trademark application, which would resolve any potential opposition dispute. If there's no trademark application, then there can be no opposition. That's a quick way of resolving things. Now, that doesn't consider your use of the mark. So I can still use a trademark even though I've withdrawn it at the registry. The only way they could compel you to stop using the trademark would be to actually sue you in court for infringement and obtain an injunction stopping you from using the mark. In most cases, as part of a settlement, if you're agreeing to withdraw the trademark, the other side would also expect you to stop using it, or they would be looking for you to sign some sort of agreement or undertaking in which you would agree perhaps a use-up period or will cease using it immediately, for example. So, yeah, in most cases, if you withdraw, you would assume that use would also be stopped. But the only body that can prevent you from using the trademark would be from the court.
Okay. So I've looked at the other side's website, and they operate in a very different field to me. So will this make a difference to how we respond?
I think so. In this case, we evidently occupy different commercial areas. I'm not going to try and imagine off the top of my head what those different areas would be, but we can, imagine perhaps you're a clothing brand and perhaps the other side market software or do software development for the car sector. We've got similar marks, but practically they're different. We would usually look at the differences within the marketplace and exactly how marks are being used as part of a pre-settlement or pre-coexistence analysis, essentially. So you could think of it as having a piece of paper with a line down the middle, and on the left side you would have what we do, on the right side you would have what they do, and then the wording of the coexistence agreement would effectively safeguard both parties' position and enable you to keep going forwards, and that line prevents you from touching. So I think it's a massive point to consider in this particular matter, and hopefully again the other side would see sense in that we have prior use, we are potentially operating in different market spaces. Most matters settle. In my experience, parties don't want the cost and the effort involved in seeing out contentious proceedings, whether that's in a court or before the UK registry. As professional advisors, we are under an obligation to always consider mediation and settlement at all times, right up until a trial. And yeah, it's something that I would be strongly recommending that we try and incorporate it in any kind of settlement of this particular dispute. It would centre on your respective uses of the mark.
And in your experience, would you say that, most companies, when they're faced with these problems, they are open to some kind of settlement?
Yeah. In my experience, the vast majority of companies, businesses, even sole traders want to settle. Of course, you get some clients that want to be aggressive, that's how they like to do things. I am guided by how the client wants to act in a particular matter. If their goal is to keep the register clear of all similar marks where there is a degree of similarity between the goods, then that's what we can go for. If we have to file oppositions or defend oppositions, then it's we're more than capable of doing that for a client. Of course, you also have to factor in budget, time constraints. For example, you may have to issue a infringement claim to meet limitation requirements, for example, or we may have to file an opposition to preserve our position if we're coming up against a publication deadline. But just because proceedings have been issued or an opposition has been filed, it doesn't prevent the parties from settling the matter once proceedings start. So, yeah, in my experience, most parties do want to settle. But again, it differs from client to client. If you've got a large company in the US, for example, that they may go after everything. They might be particularly aggressive. They might have a large budget for these type of things, so they're just churning out oppositions constantly. There's a few examples come to mind. Likewise, you might have a company that's very risk averse and perhaps doesn't want the possibility for negative press, for example, to be seen to be overly aggressive with your rights or stifling competition. A lot of large businesses don't want to be seen as picking on the small guy, so to speak.
So really, I think what you're saying is that, as we expected, these cases turn on the facts and they turn on the objectives of the particular companies involved, their market strategies, and the importance potentially of the brands that they're holding.
Yeah, exactly that. I think it's exactly how you say. Also, I think a consideration should be given to the particular sector they're working in. If you've got a client that's working in pharmaceuticals, for example, where people are relying on their trademark to indicate what a particular medicine might do or the effects of a drug, if you've got a potentially similar mark that's been filed for similar goods, there could actually be a real harm, physical harm to the public, as opposed to, let's say, for example, a similar clothing brand, which, okay, it's annoying for the rights holder to have poor quality or, similar, lesser quality goods on the market. But me owning a cheap knockoff t-shirt it's not going to physically harm me. But if I get confused over the commercial origin of a specific drug, then the effects could be quite more harmful.
Sure. So the confusion can actually determine the importance of the case, really.
Yep.
The type of confusion.
Yeah.
Brilliant.
Exactly.
Okay, thank you, Joel. I think that this wraps up this simple scenario. From an attorney point of view, it does raise a few issues. I guess that you're going to say that taking professional representation, even for what seems like a relatively straightforward filing, could be worthwhile because it could save you some cost and worry down the line.
Definitely. So in this case, we have got the threatened opponent that hasn't done their due diligence. They haven't searched online to see whether the receiving party of their threat has been using the mark. For all they know, perhaps you have an earlier registered right too that maybe they're not aware of. It would be part of the due diligence you would want to do when taking on a case. From the perspective of the applicant, i.e. the new client, attorney advice would have enabled you to draft a sufficiently specific list of goods and services that may have avoided you coming to the attention of this third party. Prior to filing a trademark, you would also always want to search the register for similar and identical trademarks. And again, with attorney advice, that's something that I would have done. And so you would then at least be aware of this third party is there. And then the decision will be up to you as to whether you take the risk with that or not. So at least it wouldn't have come as a surprise.
Sure. And the register now is actually quite a crowded register. So when you're choosing new trademarks to use, actually the risk is quite significant that you're going to run into something.
Yeah, absolutely. Especially if you're dealing with a trademark that, let's say, is a dictionary word or is comprised of 2 or 3 dictionary words. If you've invented a word yourself that has no meaning with respect to the goods or services, generally the risk posed by the earlier marks, or should I say, you'll have a little bit more freedom generally. I'm not going to reel off a load of made-up words, but you can imagine. But if you're using a mark or registering a mark that does contain just normal words in respect of, let's say, clothing or common consumer goods, then yeah, the register can look quite crowded. There's a practical shift as well amongst attorneys, and with recent case law that I think is starting to favour more specific specifications in trademarks. So we'll see how that develops. But I think in this case, the whole issue probably could have been avoided with attorney advice from the get-go.
Sure. Thank you, Joel, for joining me today. I hope that you've enjoyed listening to Figure 1, an IP conversation brought to you by Albright IP. I look forward to you joining us next time. Thank you.